Today on My Family Pod, we have Maura McKibbin, who is an accredited family mediator who practices in Altrincham. Welcome, Maura.
Lovely to be here, Jane.
And to talk about mediation generally, it might be helpful to the listeners to understand what mediation is, how it works.
Yeah, I think put really simply, it's a place for people who are separating to sort stuff out that's completely away from court and is supported by a neutral mediator. So it gives people a place to do their sorting out, perhaps more cheaply, perhaps more helpfully as parents. So it's a sorting out process, it's future focused, and anyone can come to mediation in a family context at any stage of a separation. So it could be right at the beginning or a bit later on if people are still struggling.
So people can approach you by phone or email?
Yeah, lots of my work still comes through solicitors. So solicitors will always talk through options with clients. I'm sure you do that all the time, Jane, telling them what different ways they can sort things out and what's going to be most helpful. So quite often clients are signposted to me through their solicitor, but there is definitely a moving tide towards people accessing mediation first. So knowing about it, I think more people know about it, and coming to the mediator first, and from the mediator then going to get legal advice. Because one of the important things for people using mediation to understand is you don't get advice in mediation. You get loads of help, and sometimes you talk about the law, but the mediator can't give you legal advice. So it's really important that the process is complemented by some legal advice, either each person having an advisor or sometimes one advisor helping both people, just depends.
Mm-hmm. And so could you explain how mediation actually works? Because I, as a solicitor, may refer a mediation case to you. Could you explain a little bit more about that process?
So the way that it comes to me is that I will meet both people, provided they're comfortable to do that. I meet both people always separately and confidentially first. And I do that for a number of reasons. One, because it's really important from a safety point of view to check that both of those people are coming voluntarily and feel comfortable and okay to be there. So it's from a safeguarding and safety point of view, I see them separately, but also I see them separately because they need a space on their own to tell me their story without worrying about how they phrase things, without worrying about whether they might upset the other person by talking about any aspect. So they have the space to come and see the mediator and say, this is how it is at home, this is what we've been going through, this is how it is for our kids. So both of them tell the mediator separately and confidentially their story. And that's incredibly important because that gives the mediator a really good feel for those two people, where they're up to emotionally, what's important, what they want to try and achieve, what they want to try and avoid in their sorting out process. So from those separate meetings, and there's a lot of information given to the clients at that stage, and the mediator gets a lot of information from them. And then they make a decision, it could because it's voluntary, about whether they want to come into a joint process together. And if they do, then that's organised. So you slide into a joint process, you make decisions, or they make decisions about how that will be set up. Will they meet in an office? Will they meet on a screen? Will they sit in the same room together? Does that feel okay? Or do they want to sit, or one of them want to sit separately? Maybe because it's too emotional, maybe because it's too overwhelming, or there might be reasons where there has been some domestic abuse. That doesn't mean mediation couldn't happen, but might mean that you would set it up in separate rooms. So they make decisions on the logistics of how it's set up, and they gather together. The mediator will ask them to do some preparation, usually before a first meeting, so guide them on preparation. And they come to a series of meetings. For my practice, it's an hour and a half, the joint meeting. And the mediator is there to support them to tackle conversations, to explore ideas, and to work through problem solving together. In between the sessions, they will reflect. They might take some more legal advice. They might take some financial advice. They might take a bit of mortgage advice. All of it will be discussed in the meetings so they know what their action points are. And they come to those meetings, and the idea of it is, as they go through those meetings, they are narrowing down decisions about what could be a way forward that they would both feel comfortable with, either around the financial separation or maybe around parenting planning for their children. So at the end, they're really going back then to their solicitors, for the solicitors to help them to create legally binding documents and legally binding outcomes. So until they get to that point, they are talking, exploring, looking at options, trying to reach agreements together. So yeah, it's a challenging process, mediation, but that's how it flows.
Yeah. And so I suppose the advantage of mediation are people coming to talk in sessions, aren't they? In joint sessions. And I suppose that could be quicker or more cost effective than going through the court proceedings or instructing their own separate lawyers to write correspondence to their ex-partner.
Yeah, I think that's absolutely right. It's their timetable. They meet when they agree to meet, so their meetings could be closer together or a little bit further apart. Because they're talking and they're in a room for an hour and a half and they've got support, you can make a lot of progress in an hour and a half that would take quite a few exchanges of letters between solicitors, probably over weeks and months.
Yeah.
So the potential to make progress more quickly is definitely there. And I think it's worth also mentioning, and you'll be really aware of this as a solicitor who's writing letters and trying to craft those letters very carefully and to keep the temperature down for people because emotions are running high sometimes, that even if you craft a letter very carefully as a solicitor, it can still, because it lands in an emotional arena for the other person, it can still cause a reaction that's not great. So letters can be challenging. So talking allows you to be really careful to explain things. You've got the mediator there. If the temperature's going up a little bit because the topic's difficult, you've got someone there to talk around the issue as well. So I think there's also potential to feel less aggravating, but certainly more pacey. If it works well for people, it's definitely one of the quickest ways to sort things out.
And I suppose could improve communication between separated couples where communication is sometimes quite difficult.
Yeah, it does help with that. I usually say to people when I meet them that when you separate, you have got so much to sort out at a time when you are probably communicating at your worst. Trust is low, people's goodwill is low, if not non-existent. So they're at a very difficult time to talk and to communicate well. And actually they need to do loads of talking and sorting out. So actually finding a way, and it's something the mediator can look at with those individuals in the one-to-one meetings, really to understand what communication has been like, where the challenges are, so that they can help better in the meetings. And certainly for parents who are going to have a lifetime parenting journey together, it's crucial that they learn a new way of communicating as co-parents. And that's something that they can do a lot of work on in mediation and have a lot of support with. So yes, their communication is pretty much at a very low point when we meet them, isn't it? But helping them to communicate well, to sort things out, and to learn to communicate as co-parents in a different way going forward.
Is mediation always possible, or are there cases where it's really not suitable?
There are certainly situations where you wouldn't recommend mediation or where somebody might not want to engage in mediation. It's usually to do with the personalities, the relationship dynamic, and the circumstances of separation. So if you've got a personality, a big personality, a very strong personality, and someone who finds it difficult to stand their ground, you might be able to balance that in mediation. But if it's a big difference between those two personalities, that might make mediation difficult. The relationship dynamic is key because if it hasn't been a healthy relationship, it might mean mediation is just not a good fit. That needs exploration, careful exploration. And the circumstances of separation, That might be to do with timing. If it's a very recent separation and the emotions are very high, that might mean it's the wrong time, but the right process. So that might be about timing of when you enter, or helping people by locking on some therapeutic support or some coaching support to allow them to manage their way through, even though perhaps the circumstances of separation have left them in a difficult place. So those are the three considerations, I think, for people.
And what about an imbalance of power? Because usually in relationships, we're not doing the same things at the same time. For example, in a financial mediation, one person may take control of the finances and the other person had no idea about what's been going on. Would that sort of a case be suitable for mediation if, there's an imbalance in that way?
Certainly, yes, but it needs careful consideration. So where you've got a financially confident person and a financially underconfident person, for the underconfident person, they are going to feel very nervous about being in a mediation room. So there are lots of ways to combat that and to help that person to have enough confidence to be able to work in mediation if that's what they might choose to do. So that might be to do with them working alongside a financial planner. So I've done that before where it's helpful. It might be that their solicitor's role is really important in working behind the scenes with them to look at budgets and to talk through and share experience around these things. So it might actually just be around information and education and confidence, in which case then with enough time and with the commitment to ensure that that happens, and explaining to the other person why it's important that both people feel confident financially to sort things out together. So if it's an extreme situation, then it might mean that mediation doesn't work well. But if it's a confidence issue, so the difference isn't there between control and confidence. So I think as a mediator, you're looking at the difference between if it's a financially controlling relationship with a history of financial control, then your alarm bells would be ringing and you'll be thinking, actually, maybe not mediation. Or maybe lawyers-supported mediation or collaborative practice. So there's a way of sitting around a table with your solicitor next to you to help you. So you've got to work out, is it control or is it confidence? And if it's confidence, how do you help the less confident person to feel empowered to be able to do the work with the other person?
Yes, yeah. And in terms of funding for mediation, how does that work?
So there are a variety of things to know about funding. First of all, there's legal aid for mediation. So it's very hard to get legal aid for any court process now, but the government are supporting the growth of mediation and providing legal aid funding. So if you're financially eligible for legal aid because you've got low income or some benefits that would gateway passport you to legal aid, that's relevant to know. Where parents are mediating and about issues regarding their children, there's a voucher that parents can get hold of, which isn't means tested. So every set of parents who are mediating relating to their children can get that voucher. So it only covers the first meeting, but it pays for either all or most of the first meeting. So that's helpful to know. Otherwise, people are paying privately for mediation. There are different types of services with different price points. People need to agree before they come how they're going to fund it because it's a fee per meeting and sort of a pay as you go. And the way I talk to clients about that is it's a joint process. So working out how they fund it is a joint challenge. That might be influenced by whether they earn similar amounts or very different amounts. Some people pay equally, some people pay unequally, some people fund it out of savings, but they need to think about how they're going to pay for mediation and make sure they've got a plan for that because otherwise they become unstuck. And to remember as well that they've got to think about not just the mediation meetings, but their legal advice alongside. Sometimes people need help with pensions and there's cost to that, or you might have people with a business and they need evaluation and there's a cost to that. So that's not just the cost of the mediation meetings themselves. So they've got to look at the whole thing and they've got to work out how we're going to manage our way through this and make sure that we can fund it.
Yeah, I think that's a really good point, to sort of allocate a fund for the cost of the sort of wider legal fees. So that's helpful. I guess it's quite tricky sometimes, isn't it, when one person says, well, I can't afford it, and can my ex-partner pay? I'd like that to happen, because then there's a lack of buy-in in terms of whether they're really going to commit to the process, because actually they're not paying for it. So potentially you could string it along or not engage so much, really.
That is a genuine worry that some people have. So you may have a scenario where someone says, I'm not coming unless you pay.
Yeah.
Or someone might say, I really want to mediate, but I literally can't afford to pay my half. So I think it depends on the approach of the people. But I think that it's usually a good idea if one person is much shorter on funding and really feels it's not affordable for them to pay half of the cost, to work out if they can pay a smaller percentage but still pay something. Because I think that covers perhaps the worry of the paying person that it's not balanced because one person's paying, and so the other person who's not contributing may not have the same level of buy-in. So I think, people have to work that through. But yeah, genuinely, it is a conversation that crops up quite a lot.
And so in relation to mediations, you mentioned pension financial advisors coming in to talk in the sessions about pensions or life policies or whatever. Who else might you also bring into the mediation process? Third parties that might help couples resolve their
Yes,
issues?
so they might fall into two categories: the people that are the other people that help, either financial or supporting parents. Financially, as you say, it could be a pension advisor, it could be a financial planner, it might be a mortgage advisor, it could be an accountant who's supporting conversations about what happens to a jointly run business. So all sorts of financial support you could bring into the process. On the other side, for parents, you might work, or they might work with parenting coaches. They might work with family therapists. It depends on the situation they're in and what level of support they need. But certainly there might be other third parties who would be there to support parents, not always in the sessions, but sometimes alongside the sessions. So I've certainly co-mediated with therapists in situations. For instance, if you've got a case where there's been some domestic abuse, but those two people really want to mediate, or you've got bail conditions that stop them sitting together, or an injunction that stops that from happening, you can still, provided they both feel safe and secure to mediate, you could still think about running mediation, but you've got to think about what support needs to be within that process to help those two people. So certainly therapeutic support can be really valuable, and co-mediating with a financial planner. It's a good model, to be honest with you. Inject the expertise into the process where people need it.
I can see how a financial planner might be helpful, for example, if you're working out how much it costs to run a household or how much people need in terms of their income, in terms of budget planning. With a financial planner, that might be helpful.
Yeah, that sort of thing. Or I've had lots and lots of mediation cases recently of people that are separating in their mid to late 50s. I don't know why, it's just what's happened to my caseload. So those people are separating at a really critical time in their financial lives, because they've obviously been on a joint financial plan for probably during a long relationship and marriage. They can see retirement on the horizon, but they might not be there yet. But obviously the changes that come financially when you separate are significant, and they're having to rejig all their financial planning and think then as two separate individuals with separate financial plans. And that's very scary. Divorce and separation bring enormous amounts of fear generally, I think. But I think the role for a financial planner there is helping people, I suppose, alongside pension advice and expertise. Well, if we run on with this scenario, how would that look for me now? How does that look for me in retirement? How can I put together a plan that allows me to feel confident that I'm going to have enough money and that this is going to be okay? So financial planning, I think, can really be valuable there. But as you say, it can also be valuable to help people to work out, what are my costs going forward? And some people don't have a lot of experience of budgets and things. I mean, some people don't use budgets, but when you're separating, you need to look at budgets.
So it sounds like people who go into mediation can have support from independent financial advisors or pension advisors or accountants sometimes if necessary, if there's a business, in relation to their decisions that they're making within mediation.
Yes.
And maybe they have more buy-in and power in relation to options that they can create and hopefully find a solution that is right for them rather than having a decision imposed upon them by the court.
Yeah, exactly right. And they tailor-make their solution, don't they? So they keep control of the outcome, provided they can agree an outcome together. But I think you've got much more creative opportunity when you're working together. And if you've got a good accountant that's really good at brainstorming and two people that have been running a business together and they want to either one, exit the business or exit over time or think about the tax consequences of coming out of a business, it's essential. I mean, you can't do without that expertise in the room. It's absolutely essential for those people to have access to that advice.
And I suppose that gives confidence to the person who maybe doesn't have the knowledge initially in terms of getting speed and redressing a balance there if they've got the support of extra information from third-party professionals.
Absolutely, because if you've got one business owner and a non-business owner who've been in a domestic relationship, of course the business owner knows their business intimately. They live it and breathe it every day. The other person may have no idea about that business. So actually, if you can find, and this is the beauty of working with a neutral, if you can find a neutral accountant who's able to build a rapport with the less confident, less knowledgeable financially in relation to the business, then you can do a piece of work, or they could do a piece of work with that person to give them understanding. And actually, if you're working in mediation, you've got the ability to help the business owner to understand why is that essential. It is essential because if one person is frozen with fear and lack of knowledge, they're not going to be able to reach a solution or maybe even stay in mediation. It's going to be very difficult. By neutral, I just mean somebody that works transparently with both people. So a mediator's neutral, a financial planner can be neutral in this situation, a mortgage advisor the same. So they're working with both. They might do a slightly different job with each of them, but they're essentially working with both of them in a transparent way.
Yeah. And I suppose that could also be helpful in a situation where someone comes to mediation with not much more knowledge of the finances and is very fearful about thinking my ex is hiding things or it's not being transparent, and I'm sure he or she's got much more money and where have they got this or that. And if they've got support within that process, then they can probably dispel a lot of anxiety around caused by lack of knowledge, really.
It goes back to this issue of knowledge, sort of really determining. And I think if you're a solicitor working with a client and thinking about whether mediation is a good fit for them, or if you're a mediator trying to do the same job and help people to understand if mediation could work, if you've got a scenario where one person has got all of the knowledge and the other one feels that that person is hiding things or manipulating the finances, it's really important to try and get underneath those fears, because of course it is right that sometimes people are hiding things. Yeah. And in mediation, the approach to financial disclosure won't do a forensic job that needs to be done if there's a fear and a belief that someone is hiding money. So that sort of situation, probably not going to work in mediation. That's much better where you've got your solicitor sitting, helping you to look at those documents. You might have an accountant working with you. You're doing a much more forensic exercise because of lack of trust. So is it lack of trust or is it lack of knowledge? And sometimes there can be lack of trust because of the lack of knowledge, but you're assessing, aren't you, as a professional, your client or mediators look when they meet the client separately is really trying to get a really good, solid understanding of what the worries are and therefore who needs to be helping those people.
So I think the financial disclosure process is the same within mediation as it would be outside of mediation in the core process?
The bar is just as high. People have got a little bit more flexibility about how they approach disclosure, I think, in mediation. If there's a worry about trust and disclosure, often what I'm going to be suggesting to people is do that job with your solicitors. And then once it's all boxed off and everybody's comfortable that they've got an understanding, they've seen what they need to see, the trust has been built through the disclosure process, then come to mediation. Because I think that's a better model for people. You can get very tied up in mediation because the mediator's role is neutral and you're not there as a mediator to double check all those documents. The solicitor's got that very careful forensic role. So sometimes it's a bit of doing disclosure first with your solicitors if trust is a bit shaky, or if the finances are more complicated and you've got any level of shaky trust, then come to mediation.
Well, it sounds like there's lots of benefits to mediation in terms of the time it takes maybe to reach a resolution and the cost efficiency of that, and the benefits of trying to improve communication between you, and the fact that financial disclosure process is very much, provided there's cooperation to exchanging financial information, a really, really good process. In relation to where one person comes maybe to an initial intake meeting and says, I'm very concerned about my ex taking control, he or she likes to be very dominant, or would you say that was suitable for mediation?
I think it depends. It depends on that person, how they feel. It depends on the history of the relationship as they explain it to you. So sometimes, if it's not too extreme, we call that an imbalance of power. So if it's not too extreme, sometimes the mediator can cater for that well in a session, and they need to talk to the other person about it in an appropriate way and explain why it's really important. This is a process for two people, so the views of both people are really important, and it's important that it's balanced, both in terms of capturing views and priorities and worries and ideas from both. So setting it up so you don't have a scenario where you've got someone with a personality that naturally would tend to try and take over, so that you really set it up from the beginning so that your boundaries as a mediator around these things are very clear. And sometimes that caters for it. Sometimes it doesn't. And that might mean separating people into two rooms can be really helpful, because that helps to keep a balance. It also allows the person who's feeling or has the potential to feel overwhelmed to have space to think. They can, in a shuttle mediation where the mediator's moving between two rooms, the person who's needing more support and help can call their solicitor for 10 minutes advice if they want to during that session, if they set it up so the solicitor's around, or speak to their financial planner. Or so you've got space, and I think the space and the indirectness of shuttle mediation can sometimes be really helpful. But there again, if it's more extreme and you can't create the right environment because you've got a really big personality and a more nervous personality, then it might be just not right for mediation. Mediation is just not for everybody. It's for a portion of people. Yes, there's flexibility to set it up and to help different people in different ways. But there are some people that no matter how much you work around those options, it's just not going to be right.
We talked a lot about financial mediations. Let's talk about mediations relating to children, because it's really, really helpful in trying to resolve differences over time with the children after separation.
Yes, absolutely. It probably was my driving force coming out of a solicitor advisory role and court work into mediation, was to help parents, because it's incredibly difficult to be a parent and then your relationship breaks down and you face so much uncertainty, the thought of not seeing your children every day, having, at that point in time, probably not much ability to be able to talk to each other. It's an incredibly difficult time. And I think I referenced earlier, sorting out your finances is big and important, but it's a one-off job generally. Getting in place a plan for your kids and building a co-parenting relationship that's got legs, that's going to work and hold you steady is a lifelong journey. Your co-parenting relationship is for the rest of your kids' lives. Even into their adult years, it's still impacting a separated family. Children are getting married, children are having graduations when they've left home, they're having their own children, there are then grandchildren. So all of those things, it's critically important to help parents to be able to do that job as well as possible, because research tells us that makes a massive difference to those children, to how they adjust, to how they cope with life in general moving forward. And it's a lot of responsibility for parents. They're probably personally hurting deeply at the end of their relationship, and they've got to regroup in some way and be supported to regroup, recalibrate, and find a new way forward, just as co-parents, but not in a relationship anymore. And people need a lot of help and support to do that. So I think mediation is brilliant for that, I have to say. I think it really can be helpful.
I also think that it's just wider than talking about time with the children on a short-term basis immediately after separation, because there's all sorts of things to think about. For example, the child's routine in terms of, do they go to dance classes or ballet, or what happens on their birthdays, what happens on Father's Day and Christmas and Easter. It's a wider discussion, isn't it, than what time is each child going to spend with each parent?
Yes, it is. And I think sometimes the most apparent worry is the day-to-day plan. That's when the client presents themselves, you'll feel the same, that's all consuming. But of course, it's right, of course, that there's a lot of other stuff to think about, and also to recognize that it's a developing thing, a parenting plan. Children grow, they change, parents' lives change. Sometimes they get new partners, all sorts of things happen. People move, their jobs take them to different places. In a childhood, a lot can change, can't it? And for parents to be able to be adaptable and cooperative around those changes. So, talking through all of that detail, all of the things that are really important to children as well as to parents, it's really helpful.
Yeah, things aren't set in stone, are they? And what might be right at the beginning of a co-parenting relationship when people separate may not be the same a year later, 5 years later.
No, exactly.
And I suppose they can come back to mediation at that point and discuss
yes, they can.
tweaking of things or changes of arrangements.
Yeah, and I think it's important to, because on the whole, people haven't done this before. They're very out of their comfort zone. They're in uncharted water. They really want to get it as right as possible. They love their kids. I mean, that's the one thing they still definitely have in common. Might have lots of different views and ideas about life and how things can be fair. But they really, on the whole, people really want to do a good job. But they're struggling to know. And so, we guide them, don't we, in our jobs, whether you're a solicitor, whether you're a mediator, we're guiding them. We're not telling them what to do, but we're saying, have you thought about, how do you feel that this could work well? Or, sometimes just giving clients a list of the typical things parents need to think about when they're doing a parenting plan. It's like a checklist. They can work through it and work out, we haven't talked about Mother's Day, or we don't know what we're going to do. I did a mediation this week where the little boy is preschool, and both parents want to see him on his birthday, and both parents plan to take the day off work. And they had to work out, well, what do we do the night before? What time are we going to hand this little boy over? What happens on the evening of his birthday? Now, that's really important detail for them, that he has the opportunity. I mean, he's tiny, so he's not going to have a view on it. But for them, it's important that it feels fair. It's important that they can have their celebrations with him. When he goes to school, he's not going to have the day off necessarily on his birthday. So they'll need to look at it again then. And so it allows parents to think about the here and now, but also think about what could change down the road. Can't always agree now what will happen later, but they can agree to review.
And I suppose it might also help in mediation to have discussions about how to tell the children that you're separating, because some parents may be living together under the same roof but have decided to separate, but they haven't told their children.
Yes,
That's quite a difficult subject to broach.
incredibly difficult. And it's probably one of the things that holds parents in unhealthy relationships which have really ended, because the dread of having to have that conversation with their children is just too big to contemplate. But I think you can do brilliant work in mediation to talk through that incredibly sensitively, think about the age and stage of their children, think about how that conversation might happen. They can make a plan for it. It's never, in fact, one conversation. It's always a series of conversations. You can really help parents, I think, to think about that. There's brilliant material out there. There are books. There are all sorts of things where parents can get guidance. And sometimes somebody said this to me today in a meeting: I don't want to tell the children until we know exactly what it's going to look like. And I understand that, but also to gently challenge that parent to think, well, it might be quite a long time away that you're going to know exactly how everything's going to look like. And maybe your children need to know sooner because they're already aware that things at home feel very different, but they don't really understand why. So there might be a more pressing need to have that conversation. But just reassuring parents that probably you can have that conversation without knowing absolutely everything, because probably for your children, you can do a really good job of that conversation without being able to give them absolute detail of everything that's ahead.
Yeah, that's interesting. So in relation to cases where you've got parents who completely disagree on what should happen, and maybe the child isn't seeing one parent so much, are you able to ask the child about their views?
You can include children in a mediation process. You wouldn't do it in every situation. I think to an extent, this is a developing area, I think. I mean, I do and have seen children as part of mediation. I think if the parents are in a really toxic, difficult place with each other, you have to be really careful about child-inclusive mediation, because as the mediator, if you're meeting children, you are not there to find out something for the benefit of the parents. You're not there to find out if a child wants to spend every Saturday night with their dad or every Saturday night with their mum. You're not there to ask a closed question and get an answer that determines something for parents who are in disagreement. As a mediator, you're canvassing views of children in a much more careful way than that. So you have to do a really big piece of work with parents first before you see children, to make sure their motivation is sound. They understand what it is and what it isn't. They think about even the detail of, well, if the children don't say what you're expecting or don't say what you're wanting, how are you going to feel about that? So you couldn't just meet some children without doing a piece of preparation work with their parents. And I think that if your preparation work leads you to believe that you could do harm or more harm than good by meeting children, or you could put them in the middle in an uncomfortable way, you should not be meeting those children. But that's not every scenario. There are plenty of scenarios where mediators meet children, and actually children can really like to have a space to talk about what's happening in their life. Not therapy, just to talk about it. And they can be very wise. They can sometimes give feedback that turns on a light for the parents about, oh yeah, why didn't we think of that? And children can cut through stuff that sometimes is really complicated for their parents because of the emotion. So I think it's got a real place. I think it needs to be very carefully managed by the mediator to make sure that in no way could it be something that was not good for children. It needs to be something that has got the potential to help. The children are the most important in that scenario, actually. And you have a duty of protection towards those children. As a mediator, you wouldn't want children to be caught in the middle of something, in any way that could make them feel uncomfortable.
And so when you have parents who disagree, are there any things that you could do to help discussions in children's cases?
Well, I do sometimes work with parenting coaches. I sometimes don't start a mediation until parents have done a bit of work with a parenting coach separately. if it feels very locked and antagonistic, and it almost needs to be softened a little bit before you work in mediation. So I definitely think there are things like that you can do that end up being supportive, or co-mediating with somebody from a different discipline, so a coach or somebody else that can add a different dimension. I do sometimes ask parents to do preparation by reading things. Certainly there are good coaching books out there which help parents. So I might say, I've just said to somebody today, before you come, I will want you to read the first chapter of that book, both of you, because I think it will really help you to be in a good mindset for the work you're going to do. So sometimes I will do things like that.
Yeah. So that comes on to my next question, was how do you plan for mediation? So you may have to do some reading, or what else might you do?
So if it's a financial mediation, you'll be guided on filling in financial forms, or doing that with your solicitor, or looking at budgets, looking at housing, looking at costings. If you're parents, looking at parenting planning, you might do some brainstorming around different aspects. The mediator might give you a list of things to think about before you come back to the next meeting. So there would be, you'll be guided as you go along, I think, because it's got to feel manageable for people. So there might not be lots to do before a first meeting, but there's always stuff to do. I mean, I tend to do a note after each session that includes an action list of things that people need to do before they come back. And what I do say to people is, if you don't do the work, you're not going to do good mediation. You know, you need to invest in it and do the prep. So it is an active process, mediation. You don't go to the mediator, they pull out a wand and everything gets sorted out. The hard work is done as you're going through mediation.
Yeah. And so how long do the sessions last, mediation sessions?
So my sessions last an hour and a half. I think maybe practice to practice that could vary a little bit. I feel that an hour and a half is long enough, but it's exhausting being in mediation. So I think there is a pinch point when people start to lose their concentration, or lose their patience, or lose their energy. So an hour and a half for me, I feel is a good time frame. And people often say, well, how many sessions will we need? And I think a broad industry average will probably be 3 to 5 sessions, but that depends on, are you focused on parenting planning and finances? Are you just parenting planning? So the mediator will give you a bit of an idea of how many sessions you might need, because you're budgeting, so you need to know, but you'll keep it under review as you're moving along.
And what happens if you reach an agreement in mediation?
So if you reach an agreement in mediation, your solicitors will help you, either 2 solicitors, 1 each, or maybe 1 solicitor working with both of you, which is also a different way of doing it. They will help you to convert that into something that's legally binding. So they will have been involved along the way, because I will always encourage people to be in touch with their solicitors as they're mediating. But at the end, it's a solicitor who will help you. With a parenting plan, it's not always the case that people's solicitors would draft a parenting plan if they were mediating. I might do it as the mediator. I sometimes encourage people to do that themselves as they're going along, because there are lots of templates and they can keep the costs down by doing that. So a parenting plan might be a typical outcome, which isn't a court order, but is an open agreement between 2 parents. So that they might draft themselves with support as they go through mediation, or the mediator might draft it. But on the financial side, it would typically be the solicitors that are helping, because it's a technical job and it needs their expertise.
And what happens if I don't reach an agreement, or it breaks down during the mediation process? What happens then?
It's a good question, because it does sometimes break down. And I think there are different avenues, different ways forward. Let's say you're in a financial mediation, you've done your financial disclosure, and you've had a really good go at trying to get an agreement, and you've either partially reached an agreement, or you haven't reached an agreement on any of the topics that you're discussing. With the help of your solicitor, you've got options to go into an arbitration process to get decisions on some issues. So arbitration is a bit like a private court process, so you can use it more quickly than court. You can access outcomes more quickly, but they're still legally binding. So you could use arbitration to help you to get third-party decision. You could use roundtable meetings with your solicitor's help, where you can invite a private judge to give a steer on how they would sort it out, which promotes settlement often. So There are ways to then get third-party decisions on the back of mediation. And I think, you know, as you're going through mediation, if it's becoming apparent that it's sticky and it's difficult and they might not get through on all or some of the issues, then you're already in a conversation with them, thinking about, okay, I've at the moment got parents who are really working hard to get an agreement about a plan, but then they're not on the same page. So they're trialing at the moment. They're doing a month of mum's plan and a month of dad's plan. If that doesn't get them to a compromise agreement, we've already talked about actually you might need arbitration because they need an outcome.
Because you're going to have a children arbitration.
You can, yeah. So they're already in a conversation with their solicitors. We're talking about it in mediation. So in those situations, they need to know what's going to come next if they can't reach an agreement, because that can feel really deflating. And oftentimes not on their side. They're in limbo. It's stressful. They need outcomes. So you need to be thinking about, okay, we'll give it our best shot, but there are some people that don't get across the line in mediation.
Yeah. Well, thank you very much, Maura, for coming to talk to us about mediation today. That was really interesting. Thank you.